Also, every single act of targeted assassination is then reported to the House and Senate Intelligence Committee. There is review. And by the way, I'm not opposed to after-the-fact judicial review. Virtually every exercise of legitimate presidential power is subject to judicial review. There is no inconsistency between saying the president has the power, which is our proposition, and them saying, but if he violates that power or abuses it, you can take him to court under judicial review. We don't oppose that. What we oppose is having the judiciary or the Senate or House, that would be a bill of attainder, but the judiciary in advance saying, well, maybe this guy you can kill, this guy you can't kill, when the president and the intelligence community have information that they cannot disclose. And one more point that I have to make is that you're so solicitous about al-Qaeda members. About 600 Americans are killed every year by police in the course of arresting fleeing felons. We do that without judicial review. The Supreme Court in the case of Gardner versus Tennessee has said if there is any possibility that the person is dangerous and might commit a crime in the future, if the alternative is to let him escape or not let him escape, you can shoot him dead. How do you distinguish that
Feldman.
case?
I just want to be really clear that what we're debating, and this is an answer to that, what we're debating here is the president's power under the Constitution, what he's really authorized to do constitutionally. The president is authorized, the police are authorized to use deadly force in a situation of true imminence. Absent imminence, the president is not authorized. And what we're talking about here in the real world, and we're talking about a real world case, is where there is no imminence in the ordinary sense of the term.
Imminence of what? When the fleeing felon, it's imminence of escape,
no,
not imminence of
felon,
committing another
that's
crime.
Wrong. That's
Alan,
just wrong.
I just want to.
No, that's wrong.
Noah, you have the floor for
Gardner
the next
versus
minute.
Tennessee,
Let him
read
have the
it.
floor for the next minute because I've given this side a bit of a long run. Go ahead. Noah Feldman.
The purpose of using deadly force against the fleeing felon, its fundamental purpose, is to protect the public. It's not to punish the person.
Of course, protect the public. So is
Come on, Alan.
Protect the public.
And where there is true imminence, the court has held that the executive can do that, and that makes a lot of sense.
Imminence
where
of
there
what?
is
Alan, I'm gonna give you.
Okay.
I'm gonna actually give you a. I'm gonna give you a
But he
response
has to
time,
answer
but
that
I'm about to
question.
take it away. Go ahead, Noah.
As I've said, I don't know how many times now, imminence of immediate deadly harm. That's the standard. That's the reasonable standard. It makes sense in the war context. It makes sense in the police context. It does not make sense when the administration has time to run it up the flagpole and see who salutes.
Yeah, that is common sense from this side now.
Okay,
in
so
terms, imminence means imminence means it's going to happen today. The guy's on the plane,
Well,
right?
The question is imminence of what? Now, let me be very clear. Let me put on my hat as a law professor who's been teaching Tennessee versus Gardner for the last 25 years. The law is completely clear that the person does not have to be imminently planning another crime. The imminence is he will escape unless he's shot dead. The only alternatives are shooting him dead or letting him escape. He's committed a past crime. He may commit a future crime. So the Supreme Court, for American citizens, has already defined imminence functionally. If this is your last opportunity to arrest him and he will otherwise escape, you may shoot him dead. So, Noah, you're just wrong when you say that the imminence requirement always modifies the imminence of the ultimate harm. Sometimes it modifies the imminence of the escape.